Hi, this is Joe with Ventura Fire Foundation. Before we jump into the episode, I wanted to let you know the first few minutes has some background noise that we weren't able to clean up. It resolves itself quickly, so stick with it. Roy and Jess provide a ton of great information. You can go to the show notes or to the Ventura Fire Foundation website to register for the August 7th virtual webinar that they talk about in the show. Thanks so much.
Welcome to the Firehouse Roundtable podcast, brought to you by the Ventura Fire Foundation. My name's Peter McKenzie. I'm one of the hosts. I'm a retired fire captain with the City of Ventura Fire Department.
And I'm Jason Kay. I'm an active fire captain also with the Ventura Fire Department.
And we are excited that you are going to spend some time with us at the kitchen table, learning about firehouse issues that we're trying to bring awareness to.
Thanks for joining us as we discuss the issues of being a firefighter, both on and off duty, and how it affects us.
Let's get right to it. All right, welcome to another episode of the Firehouse Roundtable. Jason, how are you doing?
I'm good. I'm excited for the show today. This is one that I think we've been talking about for a long time. We've needed something like this on the fire department side of things for a long time, and it's good to finally establish what to do. I know a lot of the conversation when we have new guys is they sit around going, okay, I got my dream job. And we go, okay, you're not done. There's some ways to set up your life. So that's what's going to happen today. And we're going to give some tips and tricks. And then I know we have a pretty exciting event with these guys coming up in August.
Yeah, I'm looking forward to it. I think it's everybody's favorite topic. I mean, I feel like everybody talks about this all the time. So what to do when you die, which is obviously a joke. But yeah, let's bring, we have Roy Schneider and Jessica Villar, who are attorneys at Schneider and Associates. But let's welcome them to the show and let's get into it. So Roy, Jessica, welcome to the show.
Thank you. Thank you for having us.
Thank you. Appreciate it.
Yeah, we're looking forward to the conversation. I'm sure you guys are, obviously well-versed in talking about this stuff. This is not a topic that, is very popular because nobody likes to talk about what happens when they die, obviously. But I think it is important, and especially in our line of work where, we see the worst case scenario in people's lives all the time. It is relevant, and it needs to definitely be. We need to normalize the conversation more. But why don't we take a second, each of you, to kind of introduce yourselves, tell us a little bit about you. That way we don't mangle your bios, and then we can kind of dive into the conversation after that.
All right. I'll start, I guess. So I'm Roy Schneider. I'm one of the founders of Schneiders Associates. Been an attorney out in Ventura County for about 40 years. Our firm opened up in August of 2012. We have 11 lawyers. One of our areas of practice is estate planning. I'm also an adjunct professor at California Lutheran University teaching business law. And we handle all aspects of business, too. We set up companies and sell companies. We have tax lawyers, employment lawyers. We've got all the needs that people have. But a big part of our practice is estate planning, and that is something that Jessica kind of focuses in. So Jessica can introduce herself.
Yes, I'm Jessica Villar. I am an associate here at Schneiders. So my background is I'm actually a transplant. I'm originally from LA, where I started off in music law. I was an entertainment attorney. I came up here with Schneiders, started doing business law, actually nonprofit, which is how I think we met you guys through the foundation. And we also do estate planning. So we started talking just out of organic conversation. That's how this came up. But yeah, that's I am currently 5 months pregnant with my first child, and so I'm excited for that. But yeah, it's a little bit about me.
Yeah, that's awesome. Definitely exciting time starting a family for sure. That is how, just for the interest of full disclosure, that your guys' firm helped us set up the foundation back in 2014, I think, is when we started. So is it? Yeah. Or you probably know more than I do, huh?
So we got brought in a little bit afterwards to help you with some things, and now we're pretty much any time that you need legal representation, we do that as well because we do focus a lot on nonprofit.
Gotcha. Yeah. So we started at somewhere else and then we came there. But anyway, you're our go-to people. So, all right. Well, thanks for giving us the bio. Let's get right into it. So let's start with the basics, because some of our listeners don't even know what an estate plan is. Start us from the very beginning. Why is this important? What is it? How does it kind of work in general?
Okay, well, estate planning is more than just what happens when you pass away. Estate planning involves what happens to your assets while you're alive, as well as when you pass away. Many times people become incapacitated, they get injured, they get ill, and who's going to handle their affairs? You have bills to pay, things to take care of, taxes to pay. Who's going to do that while you're alive? Plus, who's going to sign your name on documents if you can't, if you're not around, you're ill or out of the country? Who's going to handle healthcare matters for you? So estate planning is not just a will or a trust or who gets things when I die. It has lots of different factors. And anybody with any kind of assets at all, you've got a bank account, you've got a pension, you've got insurance, you got a house, you need to have planning. So that's, in a nutshell, that's what estate planning is. It encompasses all these areas of your life on what you're going to do with these things during your life, during incapacity, after death, and that's what estate plan basically is.
Gotcha. I think to make it realer for our listeners, what happens if you don't have an estate plan and one of those things happens? I think that will conceptualize it a little better for somebody.
Well, interesting.
Yeah, go ahead.
Well, great. I'll say a couple things and Jessica can add. But if you don't have an estate plan, the state of California has one for you, and it will decide by statute who's going to get your assets. It is also, if you do not have an estate plan and you become incapacitated, the courts may have to get involved, and a conservator will have to be appointed for you. And that is really not a very pleasant proceeding. But the court examines you, they send out people to interview you, and determine that somebody is going to have to now be in charge of you. So if you don't have an estate plan, the state of California will take care of it for you, and it may not be what you want.
Let's dive into that. What does that mean? When you say it may not be what you want, what do they do? Why would that not be to your advantage?
So on two fronts. While you're alive, and let's say you become ill or you become injured, you lose capacity. If you don't have a estate plan in place, the court will actually appoint a conservator. So I'm sure most people here are familiar with Britney Spears and the decade-long battle of her having a conservatorship. That's what that was. The court stepped in and said, since you're not able to handle your own affairs, now for her, it was for obvious reasons. Here, somebody might be incapacitated, might be injured, they may become ill. The court comes in and then dictates who's going to be responsible for you, for your financial affairs, for basically you're a grown adult now with a babysitter. And if it's a conservatorship, it's a court proceeding. So you have to go to court. The court examines you. The court talks to you. They talk to your doctors. And it's very public. It's very long. It's very embarrassing. At the end of the day, you may get assigned somebody that you don't want to be responsible for your affairs. And at that point, since you don't have capacity, you don't have a say in it. So this actually steps in front. While you have capacity, you can dictate who can be responsible for the things for you. So whether it's a spouse, whether it's a sibling, a parent, a close friend, somebody that you trust is more responsible. And let's be honest, we have certain people that we love that maybe would be great to make certain medical decisions, but you wouldn't want them responsible for your bank account and vice versa, right?
Yeah.
So that's with regards to a conservatorship while you're alive. When you pass away, if you don't have a trust or a will, then the court dictates, there's an actual by law who gets what, right? So it's in the law, it's statute, and that's the default. So if you have, for instance, children that maybe you're not close with, or if you have parents that you're not close with, but you don't have any children, and you would rather your assets all go to your siblings or a close friend, or maybe a life partner that you never got married to. That doesn't happen unless you have a document, a signed legal document like a will or a trust that dictates that. And more to that point, in California, and I love the state, I love the weather, I love many things about this, but the probate process is very long, it's very expensive, and it's very public. And you don't have control over that if you don't have a trust and plan. So even if you have a will, and we'll kind of get over that when we do our presentation in August, but even if you just have a will, you have to go through the probate process. And that's where the court steps in and says, okay, this is everything you owned, and this is who now is going to legally own it. If you have a will, you're basically telling the court who you want to own it, but the court still has to order that. Whereas if you have a trust, that avoids probate.
Yeah, the problem with probate too is it's very expensive. It's very costly. It's set by statute. Lawyers' fees, attorneys, and executive fees. It's not negotiated fees. It's costly, and it is, as Jessica said, it's public. So everyone will know exactly what everybody's getting and what you had. And if you have children, unless you have a trust, they're going to get everything at 18, which isn't a very good idea. But they will get calls from the Ferrari salesman and the yacht salesman, and they'll be spending their money before they even see it. So probate is something you want to avoid. It's just, you want to stay out of court. Once you get involved with the courts, it's a year-long process, and you have no control. You can't just willy-nilly do things you want to do. So you want to, and as I said, it's very costly. So you do want to avoid probate.
That's a good point, especially as firefighters. You don't want the big truck salesman calling you right after you inherit money at 18 years old, right? So by default, I would assume that if something horrific happens to me, and let's say I get a brain injury and I'm incapacitated, I would assume that by default, my wife would then be able to make decisions for me. Is that correct? First of all, go ahead.
It's not by default. I mean, it has to be a proceeding. If she doesn't have a power of attorney for you, or she's a successor trustee or a co-trustee, she may have to become a conservator of you too. She doesn't have automatic rights to just deal with your affairs. But if you have power of attorney set up, which is part of the estate planning process, and you have a trust, it's seamless. She just starts signing things, and everything is owned by the trust, or she has the authority to sign your name. But you have to go through those couple of steps first.
And there's also, to piggyback on that, there's two types of power of attorneys in California, and really in any state. It's you have one to handle your legal and financial affairs, and you have one to handle your medical affairs. So in California, we call that the Advanced Healthcare Directive. And so one allows them to literally step in your shoes and sign documents on your behalf, which is your regular power of attorney. What you want and what we always create is what's called a durable power of attorney. And that's an important difference between a regular power of attorney and a durable power of attorney. So a regular power of attorney, the moment you become incapacitated, it is no longer valid. You have to have capacity in order for it to be valid. So what you want is a durable power of attorney, because that stays valid even after your incapacity, which really is what you want it for. The Advanced Healthcare Directive is now dealing with medical decisions and dealing with your doctor and end-of-life care decisions and things of that nature.
So why would there be the other kind of power of attorney that would stop when you become incapacitated? Why would anybody want that kind?
So you a lot of it is for business purposes. A lot of it is just because that's kind of the default. In essence, you're granting a really strong authority. You're granting authority for somebody to step in your shoes legally and act on your behalf. That's signing legal documents, entering into contracts, buying things, buying homes, buying cars. If you don't have capacity, think about it. Like if you don't have capacity and somebody's doing these things on your behalf, that could be dangerous. So usually the default is you can grant somebody that authority as long as you know you're granting them that authority and you have the ability to say, hey, I don't want them to have that authority anymore. So that comes up a lot. For instance, I used to use it a lot in music. So when I would make a record deal and you have to sign all these documents, right? There would always be a provision that said, if you don't sign these documents when you're supposed to, you're going to give me a limited power of attorney to sign it on your behalf so we can make sure this deal goes through. It's very limited, right? And for that specific purpose. So that's a regular power of attorney. But here on the estate plan, what you want is a durable power of attorney, and that's usually pretty broad. There are a few things that it won't allow you to do unless you specifically state it, and we'll always go over that with you, and we'll ask you if that's something you want to grant the individual, keeping in mind the type of authority you're granting over.
So just to clarify for our listeners, if husband and wife are married, they have a couple kids, they don't have an estate plan, they've given no thought to this process, it is not automatic that the wife steps in and just business as usual, I'm going to handle everything. This is key because I think a lot of people have that assumption, based on the question Jason was asking. Is that accurate?
Correct. On the big picture stuff, yes, correct. That's not always going to be the case. So if it's going to be they're going to be incapacitated for a while, then at some point, yes, people are going to want to see conservatorship papers.
I got a question for you guys. What is what is the relationship between taxation and probate, or is there one? Is a trust a way to avoid taxes with probate?
Okay, so with regard to taxes, with your estate plan, there's three different taxes to be concerned about. One is income tax. When properties are sold, if there's gain, there's going to be capital gains tax. In California, as a community property state, if property is owned by husbands and wives, on the death of one, the property, whether it's stocks, bonds, real estate, all gets up to has a step up in basis, which means the IRS will treat it as if you just bought it. So if you bought a $400,000 rental property in 1995 and now it's worth $1 million or $2 million, if you sold it, there'd be a huge capital gain tax. But if a spouse passes away and then you sell it, they'll be tax-free, income tax-free. And that's regardless of your estate plan, except you should take property in community property form. Owning it as joint tenants, which many people do, they don't pay attention. They just listen to their realtors. You may lose that benefit. So it's important to look at that. That's all part of what we help you do. Also, with regard to property tax, used to be you would inherit your parents' property tax base, and people would have rentals and extra properties at a low tax basis. Now it is all reassessed to date of death value, unless your parents lived in that house and you move into that house. Then you get some property tax break, but it's not 100%. So that's a concern. And then the other concern is estate taxes, that is taxed on your death. Estate taxes at 40%. Right now, it's about $13 million per person. So you could have a $26 million before there's a tax. That's a lot. If you have that kind of money, but do not have a trust, one spouse dies, the other spouse inherits it all. Now they may be over the $13 million, and there'll be a tax. By having a trust, you can separate it. So each spouse gets the benefit of the full tax exemption. And that will go away in 2025, at the end of 2025. And it'll go back to around $6 million per person. So trust can help you avoid estate tax.
Okay, so let me clarify on this a little bit. So I know when I've bought property in the past, it's always a little confusing on how you're going to hold title, right? Whether you're talking about community property, joint tenants, survivorship, all the different ways that you can do it. If clearly getting legal advice from an expert is the best case scenario, right? Like that's what you should do. But I don't think most people go, okay, pause what we're doing here. I need to call my estate planning attorney and figure this out, right? Although arguably they should. What does it look like if somebody wanted, a couple things, we'll lump this into cost too. Like how much does it cost to get all this stuff dialed in? And then if you do go that route, like, do we have access to this kind of information if you need it? Like what does this look like logistically for a firefighter who's buying his first house and he needs to be considering all these things, who doesn't have an estate plan? Like, what does that look like? How would they go about solving these issues and getting themselves set up properly?
So there's a couple of ththings. If they don't have an estate plan yet, they don't have a trust, and they are married and they plan on taking the property as community property, what they can do is we would recommend taking title as community property with a right of survivorship. And realtors usually recommended joint tenancy because it had the beauty of being a right of survivorship, meaning once the first spouse died, the surviving spouse automatically became full owner. That was an automatic right. And so that was really what people assumed the intention was, right? If you're owning property with your spouse. California now, if you own it as community property, that wasn't always an automatic given, because the community property, you have a 50% undivided interest. You can do whatever you want with your 50%. So, but if you have community property with right of survivorship, now you're getting the best of both worlds. And that's also something that's relatively new. So that may be why not everybody who holds title that bought property a while back holds it that way. But so that would be the first step, right? If you have a young firefighter that's buying their first home or buying a investment property or whatnot, and they're married. The next thing that we recommend is you get a trust, because I know we were talking about probate earlier and why you want to avoid it. In California, if you own anything right now, the amount is $184,500 to your name when you die. That's the amount that triggers probate if it doesn't have any place to go. If those assets don't have a place to go, meaning they don't have a beneficiary of some sort. So as we all know, in this state, you can't own any property that's worth less than $185,000. It's just not possible. So the first thing we would say is get a trust. And then you just transfer it to the trust. It doesn't change anything for tax purposes. It doesn't change anything as far as rights, so long as you're the trustee. It just puts it in the trust. Now, if you already have a trust, you can actually buy the property in the name of the trust. You just take title into the trust and you avoid that altogether. And by the way, also what's good to know is that it doesn't cost you anything to put money into a living trust. So a lot of times, like when you do a deed, right, you're paying documentary transfer tax, you're maybe paying reassessment. There's all these things you got to pay for. That stuff you don't pay for when you put it into a trust. There's recording fees, but those are very minimal in comparison to everything else and the benefits.
So if you hold the property, like, because right now the property we have is held in the trust. It's titled to the trust or whatever. So then the community property thing kind of doesn't matter at that point?
Yes and no. So it doesn't matter in the sense that, so your trust is an actual legal agreement you have with yourself and with the trustees in the future. Mm-hmm. So that's what's going to govern, right? So if however the property is supposed to be handled on your death, that's what controls. It's like any kind of contract. But in the event that you were to revoke the trust for any reason, right? Whether it's you choose to revoke it, there's a divorce, whatever the reason, it comes back to you the same way that it was held. So if you put it in as community property, it comes back to you as community property.
Gotcha.
Also, it's important because that dictates the rights of you to change the trust. So, for instance, you may have separate property that you inherited, and you want to put that in the trust because to safeguard it. But that means that if it's your separate property, unless you state otherwise, usually you're the only one that can make changes to it.
Gotcha.
Your spouse can't just give it away, without your permission.
What does all this cost? I mean, not like to the dollar and cent, but just ballpark figures if someone wants to set this up the right way. I would say it ranges probably from about $2,500 to $3,500. And we do everything on a flat fee, and that's going to cover drafting your trust. And I'm also talking about a couple here. Drafting a trust, drafting 2 wills, 1 for each spouse, drafting 2 advanced health care directives, drafting 2 durable power of attorneys, and then all the supporting documentation. Now, where it varies, why there's like $1,000 variance, it depends on if you own lots of properties that we have to transfer. If you own side businesses, I know that's very common in your field is for people to have side hustles. If you have that, you want to put that in the trust too, but that also requires documentation. And then also how difficult or how imaginative you get on the distribution. So if it's very simple, like you have adult children and it's 50-50 distribution and you really don't have to say a whole lot with regard to that, it's relatively easy. If you have young children and you have children from, let's say, a previous relationship, that's going to take additional drafting because we have to make sure that we account for that and make sure we protect their interest and your wishes with regards to drafting that. So that takes a little bit more work. Gotcha. Now,
sometimes people have children with special needs, and that has to be accounted for too. And that can cause an increased cost because you don't want the child to lose their government benefits. So also sometimes people have property in other states, and that all increases the cost a little bit. So it depends on the complexity of the estate. What we like to do is we would meet with people, they fill out a form, a questionnaire, and after we get a full handle of what they have and what their wishes are, then we come up with a fixed fee. And it's usually in the range that Jessica mentioned.
Gotcha. And by the way, the meeting's free.
What's free? Sorry?
The initial meeting where we talk to you.
Oh, okay.
That's a free hour consultation.
So firemen are notorious for trying to do things themselves. What are the risks if somebody goes online and tries to figure this all out on their own?
Don't do that. Don't do that with your estate plan. Don't do that with any of your businesses. I will say probably a third of my work is cleaning up those messes, and it ends up costing them about 3 times the amount of money that they would have spent had they just came to me to begin with.
Yeah, gotcha. The problem is they don't know they made a mistake until it's done. And what we've seen is you go through these online places or other kind of services that aren't lawyers, they say, gee, I got all these choices. It's the same price. I think I'll select all these choices. Well, they're contradictory. They don't work. And you end up with this total mess. So you should never try to do it yourself.
Or the other thing, a common thing I see is they think they created a trust and they didn't. It wasn't properly done. So it's not really a legal document. And then they start taking title in that. And that creates a mess because now we have to unwind everything. We have to transfer everything back. We have, And every document we have to prepare, everything we have to file, that's more money. And also we have to kind of track it down and start asking questions. And you got to try to remember, like, where did I do this? How did I do this? Who did I open this account with? It's a mess.
So stick to the home improvement projects on the DIY side.
Yeah, definitely.
One other thing, sorry, and then let's go to Jason. He's got his hand up. When is the right time to do this? Should you wait till you have a bunch of assets and you're all set up in life and you've got it figured out, or when is the right time?
So here's the thing with an estate plan on two fronts. Like we were saying in the beginning, it's not just when you die, right? It's also to plan and prepare for if anything were to happen to you now. And it's one of those things I always say, this is part of adulting. Everybody knows adulting sucks. Nobody likes it. But this is just part of it, right? So the way you draft these things, it's like if the moment you sign, you walk out of our office, you're going to get hit by a car. So even if you don't, let's say you don't own property yet, right? You're 18, 19, 20, but you are in the field. You definitely want a durable power of attorney. You definitely want an advanced healthcare directive, right? And you also want a will. If you have any kids, so here's the other important thing about a will. If you have any kids that are minors and you want to nominate who their guardians are, and should you and your spouse pass, or you and their other parent pass, you name that in the will. That's where you put it at. So if you don't, then again, it goes up to a court and the court decides. So the short answer is the moment you become an adult, whether you want to or not, is the moment you should have an estate plan.
There's no magic number. And I think if everybody takes a minute to think of all the stuff they have, cars, boats, coin collections, baseball cards, furniture, silver, things they've inherited, add all that stuff up. It's stuff. It's all going to be just given away, thrown out. And so it's stuff that you want to, deal with. Your estate is large, and it doesn't matter. It's not a dollar amount. It's all the stuff you have. Now, if basically sometimes older people, let's think grandparents, they've kind of spent a lot. They don't have any real estate. They just have cash. You can set up payable on death accounts, which people do, where you can have your investment accounts, your bank accounts, just set up so when you pass away, it goes to certain people. And you can avoid having some other documents, but you still need power of attorneys and a healthcare directive.
And you still want to talk to an estate planning attorney because we want to make sure that you're accounting for all of that. I think sometimes one of the biggest benefits of talking to an estate planning attorney is the light bulb moments, because we ask the questions that you don't think about. Why would you think about it? And that's what we do, right? And we also, because we do this on a day-to-day basis, we see all of the unlikely but possible outcomes because they come across our desk. So we know to ask those questions so that you can plan and prepare for it. 9 times out of 10, you don't go to an attorney because best case scenario. You go to an attorney as a CYA for worst case scenario. And we just plan for that.
Yeah. Jason, what'd you have?
It's funny you guys say that because that's exactly what we deal with in our job aspect too. You call us when it's worst case scenario most of the time. So I understand that thinking. I feel like you guys are masters at this stuff. Peter is maybe in college. So I'm going to come at you from the elementary school side of this. And I'm going to take it way back to probably where we should have started for somebody like me and dumb it down even further. So when we have a 25-year-old, which is on the younger side of guys getting hired, when they come to work, I tell them you need to get life insurance and a will for sure for your family as soon as you have a kid or as soon as you have a house. Can you break down, first of all, why they need a trust? And honestly, I would say, what is a trust as compared to a will, and how does all that fit in?
So they're both testamentary documents, meaning they're documents that state what you want to happen in the event that you pass away. Both have their benefits, but one, being the trust is a lot more beneficial. So what a will does is it tells the probate court what your wishes are should you die. And now this goes with your property, then this goes also with your minor children. But it still has to go through the probate process. So this is that thing we were saying, you want to avoid the court or California making the decisions for you, making the decision where your assets go, making a decision who is the guardian of your children. but it still has to go through the probate process. And that's the process that we're talking about. It's very long, it's very public, and it's very expensive. And at the end of the day, that's now your wishes may be granted, but they still have to go through that because the probate court still has to order it. Whereas, and that's the thing that we were saying, if you own assets, as of right now, it's $184,500 to your name, you have to go through the probate process if those assets don't have a place to go. A trust avoids that. So a trust does everything the will does with the exception of the guardianship. It does dictate where your assets go, but you can own as much as you want. As long as it's in the trust, you avoid probate in California. Now, keep in mind, this is California specific. Every state's different. So as long as you have that's the reason why you have a trust. So if you own property, you or like Roy was saying, you own assets and you add it up and it's more than $184,000, you get the trust. You also still have a will. So that's other misconception is that people say, if I have a trust, I don't need a will. No, you still need a will. Even if you have minor children, because it deals with the guardianship. And two, it is very easy to own assets and forget to put them in the trust. It happens all the time. You buy a car, you buy it in your name. You refinance your house, you pull it out of the trust to refinance, and the mortgage company doesn't prepare the deed to put it back in the trust. Or you just think something's in the trust, the name of the trust, and it's not. So when you have an estate plan with the trust, that will is actually called a pour-over will. And what it does is it tells the probate court, hey, anything I have that's not in the trust, pour it into the trust. So your trust still governs.
Yeah, the important thing about the trust also, if you're a young firefighter and you're told to get insurance, you get $1 million life insurance. Okay, maybe it's payable to your spouse and you have small children, but your spouse passed away. You both passed away. Now there's $1 million and there's, a 5-year-old. Well, they're not going to give $1 million to a 5-year-old. You'd have to get a court-appointed guardian and they'd have to make reports to the court all the time. It's a big mess. That's why you have the trust. Then $1 million goes in the trust. That's your second beneficiary. And then your trustee, who you've named, a mother, a sister, whoever you've named, they then will manage that money and protect it for the child until the child reaches what age you think is appropriate. So that's why even a young firefighter with not a lot of stuff yet, they don't have life insurance, that's a bunch of money, there should be a trust.
Okay, that makes a ton of sense to me. Now, when you talked about if you only have a will and not a trust and it goes to probate, are you still paying all of those probate costs and fees?
Yes, you are.
Okay.
Yeah,
and then how often or what things should somebody, just use myself, be making sure that you now have in the trust? So some of the stuff you just said with buying a new car, refinancing your house, is that like a question that's typically asked when you purchase big items?
Yes. So, no, it's not. If you have a smart realtor, a very smart title company, they may ask that question. Unfortunately, it's kind of left to you when you're making those purchases to say, I want to put in the trust. Now, we're talking about material items here or real property meaning like what we think of as property, houses and land. That you can always put in the name of the trust because there's an actual title there. Same thing with cars. Now, unless you own, a car that's over $250,000 or the $184,000 mark, it's not dead. It's not going to, you're not going to have to go to probate over a car. There's some exceptions to that, but it just makes everything easier. And then what also happens when you create a trust is we do what's called a general assignment. So anything that you own, you're assigning to the trust. So let's say you forget to name it in the trust. We take that general assignment and we take it to the court after you pass and say, hey, they forgot to put it in the name of the trust, but they owned it at the time they signed this and there wasn't a general assignment to the trust. You avoid probate, the court just signs a petition and puts it in the trust, and you can avoid that whole process.
Okay, so you said something super interesting that I didn't catch the first time. You said if the car is worth $184,500, more than that, then it needs to go in the trust. Does that mean that each thing in the trust is individual? So, or is it a total of over $184,500?
So the $184,500 number in California, that's the smallest state's affidavit number. So that's the amount of money that you can own, the amount of worth of your assets that you can own on your death without having to go to probate. It has to be under that amount. If it's over that amount, then you go to probate.
If it's over that amount total, and you buy $50,000 car, that is something that you would then need to put into the trust as well, correct?
So yes, we would recommend putting in the trust. You can usually there's ways for cars, certain property you can actually go and under that separate and apart from that amount, and you can kind of deal with the DMV directly. But we do recommend, especially if it's a high material worth, like a collectible car or just a car that's worth a lot, easier to go into the trust because then there's no issues as far as dealing with it and who has legal title.
Okay,
yeah,
I understand.
For a simple matter, you want to put everything in the trust. That's what we hit people with. You buy a car, you buy a boat, you buy a plane, you buy anything where there's a title to it, just put it in the name of the trust. It makes it so much easier when you pass.
But the key thing that was trying to make a difference is if it's real property, that is extremely important to be in the trust. If it's a car, if you own, a F-150 and you buy it in your name and you pass away, you're not going to have to probate that. They can go to the DMV and show your death certificate and, there's ways to get around that. But it is extra steps for your loved one to have to go through that versus if it's in the trust, there's not a whole lot they have to do.
Hi, I'm Austin Folk, an engineer with the Ventura City Fire Department. I'm also on the board of the Ventura Fire Foundation, an organization that supports firefighters and their families. The foundation produces this podcast as part of our mission. I worked with the foundation because I was witness to the help that it was able to provide to my family. The foundation needs your help. First, please subscribe and rate this podcast on your podcast platform. This helps us get a higher ranking and more visibility for the show. Second, if you support the podcast and the foundation's work, please consider donating. Every dollar helps us support firefighters and their families. There's a link in the show notes, or you can donate through the website at www.venturafirefoundation.org. Thank you for listening.
I just want to speak to something for our listeners' sake who hopefully are considering, okay, I'm going to go do this trust thing. Like I need to talk to Schneider and Associates and figure this all out. On what that looks like. So obviously you guys didn't do my trust. This was years ago, but when I went through this process, it's not as like intimidating and as daunting as it sounds, just with all the legal talk that we're talking about. Mm-hmm. There definitely are those light bulb moments, just that you were referencing. And I vividly remember sitting in the room with the attorney, with my wife, and going, oh yeah, we think we got this all figured out. Kids are going to go here. This is going to go there. And then the questions started coming like, well, do you want the money to go to them when they're 18? Do you want us to delay it till they're 25? Do you want to do, if this happens and that happens and all these scenarios? And those were the things that I think are invaluable. Like you were referencing, like, I didn't know the answers to these questions. I never even thought of the questions, but the fact that the attorney was asking the questions was spurring conversations between my wife and I on, oh, there's more to this. We need to give this some consideration. In fact, we left that meeting and had to go home and continue the conversation and decide what we actually ultimately are going to land on with the answers to all the questions. But for the sake of our listeners, they walked us all through it. It took a couple of hours. You paid your money and it was pretty much done. I think you do need to modify like how you take title to things. And there's some things you need to do on an ongoing basis, but the actual, like, we're going to do this, it's not that big of a deal. And which is why it's important that you use an expert who knows how to do this, specializes in it. Because I could imagine if you have an attorney who practices a different kind of law, who's going to try to set you up an estate plan, probably not a good idea, right? You want somebody who does this day in and day out. So I just wanted to put that in perspective for our listeners who are saying, okay, I need to do this, but maybe they're going to put it off because they think it's going to take them weeks and weeks of their time. So do you want to talk to that, Jess?
Yeah. So like Roy was saying, you come in and we have a consultation, and that with our firm, that's free. And we sit down, and what we'll do is we send you a questionnaire beforehand, and it has the main points, right? The big picture item stuff. You send that to us beforehand. We take a look at it. Then we sit down. We start having the conversation. And depending on your answers, then we start asking those questions that, have the light bulb moments. After that, what I usually like to do is I'll send you a summary of what we discussed and the questions that we had brought up. Because nobody, like you said, right, you and your wife had to go home and have that conversation. You're not going to have those answered right there and then. So I like to email them to you so you guys can have those conversations. You give me the responses, and then we draft it. And you take a look at it. If you want to make changes, you need to make changes, we do that. We for lack of a better words, we hold your hand through the whole process. And there's no such thing as a dumb question, especially anything legal. There's no such thing as a dumb question. We went to law school, you didn't. So we don't expect you to know any of this. And you can Google questions and you get 3 different answers. So definitely come back to us and ask us, because then we'll put things in perspective and we'll answer it. Or we'll find the answer for you if you don't have it right away. I think that's really important. So it's not, I know this sounds scary. I think the scariest thing about this whole situation is if you don't do it. I know it sucks to talk about, but like I said, when I always give estate planning speeches, it's part of adulting. Nobody likes doing it. It sucks, but it's just part of being an adult.
One of the things that makes us a little different than other estate planning attorneys, we're very attuned to the concept of family dynamics. And it's very important to look at how that family is set up. And in picking your financial fiduciary, for example, a number of families say, we'll just make my eldest daughter. Well, she may or may not be the best choice. You may have siblings who are going to be, how come you're the trustee and I'm not? Who should take care of who? The last thing you want is to have a child be trustee for another child. That's a mess. We've seen situations where, I think I'll just name my brother as trustee, not my kids. Well, that may not be the best, because those kids are going to call your brother every day. I want money. Yeah. I want money. And eventually they give up and they give them the money. So picking that financial fiduciary and family dynamics. And I'll tell you something interesting is that when the last parent passes away, the children revert back to their adolescence. I don't care if the children are 70. They all become 16 again. And how come mom liked you best? And why did you get that? And dad promised me the baseball. And that's family dynamics. And we have a whole presentation just on that. And a lot of times people don't think about that. And keeping the family together and not fighting is sometimes more important than who gets what, when, and where, right? Because they do. And if you name one child as trustee and the other siblings don't get all their money within a week, they're convinced the person's stealing. So it's important to think about that.
Peter, you want to say something?
Yeah, I can speak to that. So unfortunately, I have way too much experience with this. So in my own family, my mother's side, and this happens, right? The second the grandparent passes away, the boxing gloves go on. And then in my professional life, because I own a property management company, and the biggest messes that we have to unwind and deal with are when the parents pass away and the kids are left with rental property and the fighting begins. And I see that way more than we want to see. And it is a giant mess. So I can just vouch for what you guys are saying. Like it is a nightmare.
It's 2 things I would bring up to the point. One is it's usually the people you don't expect, right? Like I remember we had a client and there was a sibling that had some substance abuse issues, had been in and out of rehab, had always lived with one of the parents, and they were supposed to get a certain amount of inheritance. And that was the one that all of the siblings were like, that's going to be the problem one. They're going to demand this, they're going to demand that. And I said, okay, let's set up a meeting. Let's have a conversation. Let's see if we can get ahead of this. And they came in and we sat down, we were talking about it. And I said, okay, what is it that you would like from this? Obviously the trust is what it says, but there's a lot of wiggle room depending on how it's drafted. And I kid you not, the sibling looked at me and said, whatever it is that's going to bring my parents back. If it's not going to bring my parents back, I don't want any of it. And I mean, the sibling was fine with whatever they were given, because at the end of the day, it didn't mean anything to them, versus the people that usually make the biggest hassles and headaches are the people that are the beneficiaries that are already well off and they don't need anything. Right. So it's not always like Rory was saying, people revert back to, you would be surprised the way they act. So keeping that in mind. And you brought up a good point with real property. It's not, and this is your property. At the end of the day, let's make this very clear. This is your property. You can do whatever you want with it. And we will talk to you. We will give you all the warnings. We will objectively say this is what could happen. But at the end of the day, it is your property. You can do whatever you want. If you want to leave it all to a nonprofit, if you want to spend every last time, you can do whatever you want with it. But leaving property to multiple siblings is never a good idea, especially if they're married. Because now you have multiple others.
I want to talk about that specifically. And this transfers over into our work as a nonprofit. Obviously, our foundation's a nonprofit. What is the cleanest, best way, in your guys' opinion, to handle the assets of a trust? And this coming from a little bit of like personal question for me, because I kind of have a problem with leaving a bunch of money to my kids and knowing that the kids are going to fight over it and the boxing gloves are going to come on. Or there's people in our nonprofit world that they leave, they leave their assets to a nonprofit and they'll put that in the trust. And I know you guys probably have some experience with that. And I'd like to expand on that a little bit too, because those are opportunities for nonprofits to, raise funds and do the work that they do. But you guys have seen the good, the bad, and the ugly. So what is the best way, in your opinion? And obviously it's your client's stuff and they ultimately get to decide. But from your perspective, is it better to liquidate everything, divvy the money up and call it a day, or give it to a charity? Or what do you see in this regard?
Well, it's interesting. Parents have different views, and different decades have different positions. At one time, parents had the view, I want everything to go to my kids. I want nothing to go anywhere else. And then it's become, I don't want my kids to all to be just, cut potatoes and live off trust funds. And so it goes back and forth. It's all very individual. Leaving money to charity, one of the things we always ask is there a charity? Is there a church? Is there something that means something to you? Leave them some money. I mean, even $10, $15, $25, $50,000 is not going to change your kids' lives. It means a big difference with charity. So we always encourage that. The other thing that's to think about it, and it's up to the individual person, is once they come up with their plan, should they discuss it with their children or not? And one of the problems that sometimes we see too is parents want to control their kids' lives from the grave. And they'll get money if they do certain things, and if they don't do certain things, they'll get money. We're going to hold it in trust till they're 50. If they marry this person, we're not going to give them money.
Or go to certain college.
Yeah, it's too much, and you don't want to control life after death. Sometimes you can leave money in trust for their lives if you think they're not responsible, and then give it to the grandkids. It's just so individual.
The one thing I will say this, and this is what I always tell my clients at the end of the conversation. At the end of the day, what really matters is you have two ways to look at it. One, either you can try to plan and prepare and get ahead of it and avoid as much fighting and discontent between everybody as much as possible and try to, account for that. Or, and we do have a lot of clients that take this position. There's nothing wrong with it. They can say, I'll be dead. I don't care. This is what I'm saying. This is how it's going to go. I won't be around to deal with it. So, and they're adults, let them deal. Let the chips fall where they may. As long as you can go to sleep at night with a clear conscience, it does not matter what view you take, as long as you're comfortable with it. Because at the end of the day, that's all that matters. It's your assets. It's your life. We're here to give you the objective views and opinions based on our experience. But a trust is a very subjective thing. So it's going to come down to what you're okay with and what your circumstances are.
Yeah, that makes a lot of sense. So August 7th, you guys are doing an event / webinar for us. What are we going to be doing? If someone's interested in coming to that, what's it going to be like? What are they going to learn? How's it going to look?
So we're going to go through all of the things that we're talking about in more detail, and it's going to be more like the legal stuff and really what the document does, and things that you have to think about when you're drafting it. So the power of attorneys, the durable power of attorneys, the advanced healthcare directives, the wills, the trust, the different ways you can have a trust, right? Let's say if you have minor children, when you draft the trust, you want to draft what's called a pot trust in there, and we'll explain that. If you have children from a previous relationship, that's something to really keep in mind. Then we can give recommendations on how you can draft certain provisions to make sure that if you were to die before your spouse, your child from the previous relationship is taken care of and doesn't get cut out. That, believe it or not, happens a lot more than people would realize or think, because you marry your spouse, you stay married for a long time, you would never think they would do that. It happens a lot more often than people think.
Yeah.
So we explain that and how to kind of account for that, and you can actually control that before, and make provisions for that, things of that nature.
Gotcha. So yeah, it's our recommendation that our listeners attend, and we'll have all the information more than likely on our website. It's August 7th. Roy and Jessica are going to be putting it on, so definitely attend that, because we can get some more clarity. I know we've been all over the place talking about every different aspect of it, and probably more confused than you are, having more clarity. But if you come to the webinar that we're putting on, and this is right in line with what the foundation is doing, like our goal is to, make a positive impact in the people that we influence, which is, firefighters and their families. And this is a big part of it. Like if they don't have these conversations, if they don't set up the trust and the will and all that, they're essentially screwing their family potentially. And nobody intentionally wants to do that. So I think this is pretty valuable information that that you guys are going to provide.
Yes.
Okay. We were looking forward to it.
Very much so.
Yeah. Jason, any parting words or?
I just had one more question to throw in there. A lot of this has been talking about once you set it up, the initial cost. What are the fees to change some things inside your trust? Is it kind of time-based?
So it depends on the changes. If it's just a minor change, let's say you decide to change distributions, or let's say you decide just to change successor trustees, that's a common one that changes over time. It's merely an amendment. If we restate it, then it's going to be a little bit more expensive, or it actually could be cheaper depending on the amount of changes you want to do. So the initial setup is always a flat fee. And anything after that, unless it's something that's pretty material in nature, we charge hourly. An amendment, if it's, like I said, pretty small, maybe takes an hour. I charge, I think, $400 for an hour. So that's all you're looking at. If like I said, if it's going to be a whole lot of changes, or if you don't want your beneficiaries to see the changes you made, and we do a restatement, then, and we'll get into more of that in the presentation, then that might be a bigger fee, but it'll be a flat fee.
Okay. I appreciate your transparency, and I will definitely be there on August 7th. I'm looking forward to the seminar a lot. I've been meaning to set one up pretty much forever. So yeah, I'll be there for sure. And I appreciate you guys being on the show with us today.
Okay. Well, thanks for having us.
Thank you for having us.
Take care.
Jason, that was a ton of information and frankly a little bit confusing. How'd you feel about it?
Yeah, I felt the same. That was some high level tax planning, especially, and estate stuff. And I'll tell you, my big takeaway from it is that this is important. I'm going to for sure attend the webinar on August 7th. And, I'm going to put myself out there and say that I don't have a trust. And I have some assets that, are up at risk right now. I've always had a will and life insurance, and I've always known I should have a trust, and my parents do. But this is absolutely going to push me over the edge and get me there.
Yeah, I think the main takeaway is do this. Put an estate plan together, because it's literally either your spouse and your kids that you're screwing or your kids that you're screwing, and no one in their right mind would do either. So definitely. And then obviously hopefully on August 7th at the webinar, it'll clarify a lot of things for people. And I'm sure they're going to be way more methodical in how they present it. And part of that was our fault for just asking random questions all over the place and jumping, around from topic to topic. But just for our listeners' benefit, it's August 7th. Go to our website, venturafirefoundation.org, under upcoming events. You can find all the info you need to attend the webinar. Arguably not the most exciting subject, but definitely one that needs to be addressed.
Yeah. And I think that, like you said, it'll be more specific. And then more than anything, when you get to sit down with one of them, I think they're pretty relatable, and they would go through your specific situation in life and get you there.
Cool. Well, thanks as always, and look forward to these events, and we'll go from there.
All right. We'll see you soon.